Good afternoon, dear participants, and welcome back. Well, the next the next session is going to be conducted by Dr. Vikas Gite sir, who is already here. So I would love to request Sagar Barguja sir to give his brief introduction.
Good afternoon, everyone. I'm going to give a brief introduction of Dr. Vikas Gite sir. Dr. Gite sir has Dr. Gite sir is working as an assistant professor at School of Chemical Sciences, KBC, North Maharashtra University, Jalgaon. To talk about his educational qualification, he has completed his MSc from KBC, NMU, Jalgaon in 1999. He has passed state eligibility test in 2001. He has completed his PhD from KBC NMU Jalgaon in 2005. He has also completed postgraduate diploma in intellectual property rights from IGNOU in 2021. To talk about his work experience, he has 18 years teaching experience and 19 years research experience, and he has guided around 16 PhD students so far. To talk about his special achievement, he has filed 3 patents. He has published around 63 research papers and has also presented papers in 57 conferences. Apart from this, he has written some books, worked on some important projects, and received prestigious scholarships, awards, and prizes. He is also serving as a research paper reviewer of some renowned international journals. So now I'm going to request Dr. Vikas Gite sir to conduct this session. Dr. Vikas Gite sir.
Thank you very much, sir, for nice introduction. I am thankful to you and your organization for giving me chance to interact with people from various areas. So I'm sharing my screen right now. Is my screen visible to you, sir?
No, sir.
No, sir, no. Now it is okay, sir.
Okay, thank you, sir. So we are talking on the essentials of IPR in innovation management, which is a very important topic in today's scenario. We have seen that in last 10 years, we are looking for very fast speed or development in almost every area in entire world, and that is supported by IPR and innovation. So what exactly IPR is and how your innovation can be protected, that we are going to look here. So I have here the first slide for you people, that is innovation, invention and property. Actually, innovation and invention are very close terms. Innovation is a conversion of ideas and introduction of new goods or services or improvement. So that is innovation, which is introduction of your conversion of ideas. And in invention, you have a tool, you have article, you have something which is better in functions and performance than the earlier existing similar material or may not be existing. And property is something good and something of value. It may be in terms of money, it may be in terms of some other kinds of assets. So these are the 3 terms what we are going to look here, and we are looking their interlinking as well as the importance of this property, how invention can be a property that we'll look for. Now I have one question, that which of the following laptops will you buy for reading newspaper? if I have this question to you, we have two laptops in front of us, which is very old laptop, and this is a very new laptop having foldable system. So you can look here how it can be fold, and the screen is bigger, almost entire part is covered with the screen, so you can read newspaper or something like very easily with the help of this new laptop. And therefore there is a obvious answer that second one, that means this right hand side laptop is the best laptop among between these two, because it is with better functions and performance than first one. So this was already available, and this is invented. This is invented, so this is the innovation, and it has better functions than earlier one. And this is a continuous process. Nobody will stop here. Even this may be older after few days. There may be some new technology, new invention, and that time this laptop, what we are calling, it's ultimately fine or the best laptop, that may not be best at that time. So this is a continuous process. Now in this continuous process, we can see what exactly creation cycle of invention to property is. Creation, or your idea is there. Your idea you converted into reality, so that we call invention. And this invention we respect for protection. So this invention we are not copying easily, because we have patented it or we have acquired intellectual property rights of that invention. So nobody should make it, sell it, or import it without your prior permission of inventor. So that is a respect for protection, and we should practice it, or we should supply it to the other people so that we can make a profit. So this is the creation cycle of invention to property. So though it was a simple idea in your mind, you have converted it into invention, and you can sell it and you can bring the profit here. So this creation cycle can be shortcut from invention to the practice and profit. You can skip this process here, that is quite possible. But if you skip this process, then that time you don't have IPR of your invention, and people will not respect your invention. They may copy, they may take your invention easily. People are very smart in today's world. Once they see what you prepared, they can easily copy and make, and they are not invested any money in developing that material, and therefore that can be very cheap for them to sell into the market. Instead, you have let down your time, you have let down your money in preparation of prototype to your actual article. So lot of time, lot of money you have invested, and you expect after selling of this article or after selling of this material, you should come up with the substantial amount which will have benefit or profit over your manufacturing, as well as that will overcome the money and time which you have invested previously. And therefore your article may be expensive. Instead, if somebody copies your article and they manufactures, then that time they don't have invested their time, they don't have invested their money, and therefore they can lay down you same copy or same material with the low cost. That is quite possible. And that time you will suffer from market losses, because the same article is available in cheap cost, lower cost than what you are offering for. So therefore people will go for low cost material, and it's quite possible your business may come in trouble. And that's why we have to go for intellectual property rights, whatever the intellectual property is involved here. It may be patent or something different. So what exactly intellectual property is? So this intellectual property is a non-tangible form of property that is a creation of your mind. We normally have properties like car, farm, houses. These are tangible properties, and this can be registered to the registrar available in your area, maybe at district place or tehsil places, and we can have ownership of that. And we know if somebody want to use your property, they should use it with your prior permission, and probably you can earn some money. Sometimes if you want to give your car, you can give it on the rent, and that time you are earning something. Same thing is with the building and some another tangible kinds of property. But if it is an idea, can idea be protected? Can idea be considered as a property? Yes, it can be protected and it can be considered as a property, and that property is your intellect property. That is, we are calling as a intellectual property. And the rights acquired through intellectual property are intellectual property right, which we are calling as a IPR. And this IPR can be patent, this can be copyright, this can be industrial design, this can be layout design, trade secret, or trademarks. So these are the various ways of intellectual property rights available to you people, and according to your need or according to requirement, you should go for this intellectual property. Now I'm coming to the patent statistic here. This is the patent statistic obtained from WIPO, that is World Intellectual Property Organization. So this we just today I downloaded it, and you can find patent application for the top 10 offices. So previously it was United States. Now United States is on the second number. China is on number 1. They filed 14,97,159 patent application in the year 2020. United States filed 5,97,172. Japan, Korea, and India 56,771. So you can find here the countries which are filing more and more patents. Those are seen here, and this is the list of top 10 countries with the highest GDP. So there is a direct relation between filing IPR and income. Now here you can find United States is still on number 1 and China is on number 2, whereas here in the patent application order is reversed. This is because United States was continuously filing largest number of patents in last few years, whereas China superseded it in the recent year. So still United States is having more number of active patents compared to the China, and therefore still they are earning more money compared to China. Whereas these numbers can be more or less similar, and from this graph or from this figure we can learn that we should file more and more IPRs for our innovation. Otherwise we will think people will copy it. This is about the PCT top 10 countries. The difference between this is here we have India 56,771, and we are still in the top 10 GDP countries. But here we are not from because of filing more patents, but here because we have the other sources, we have manpower, we have agriculture goods where we are not filing patents, still we have a lot of income from that, and therefore we are standing at the 5th position with $2.65 trillion economy, and not because of this. This is the number of filed patent, but second file clears you we are not in the top 10 countries. This is the list of top 10 countries which are filing PCT. PCT means International Patent Filing System. So whatever the patents filed in India, these are by the foreign parties, are more compared to the domestic patents. They want to protect their product in India. They want to sell their product in India, and therefore they are filing patents in India. And that is why the number 56,000 is here. Okay, so that indicates we still lagging behind largely for innovations. Actually, in fact, Indian people are with very nice system. They can have a lot of innovations, but there are some lacunas, and because of that lacunas, we are not able to convert that idea to the profit what creation cycle I presented here. There were many reasons. One of the reason is if you want to convert that idea to prototype to actual article or product, lot of things are required. Let it be registration of company, let it be having analytical facilities, let it be having mentorships for starting your business. So there were issues related to this, and that's why we were not able to dare to start our product, even though we were having very good ideas in our mind. But nowadays, on introduction of incubation centers or government's initiative since 2013 or previously also, we are slowly making up, and that has resulted into 8 unicorns in the last 1.5 months only. So this is the largest number of unicorns in 1.5 months only. So unicorns are startups which are making business more than $1 billion. And if any startup makes business more than $1 billion, it is treated as a unicorn company. So you can find unicorns are more in India in last 2 years because we invested many years, last 7, 8 or 10 years, we invested to improve your incubation activities or provide facilities for the startups. And similarly, you also can think of, but these startups should be supported by IPR, and unless and until you are supported by IPR, you cannot protect your product. You can find here, this is the total patent application. Patent applications are around 32,76,700, and out of them, around 45% of applications are made by China. And we know US is on number 2 now, and China is on number 1, and that is why China's income is increasing very fastly. Their GDP is increasing very fastly, and it is predicted in near future or within few years, they will cross United States in the income also. This is because of filing more and more patents, because of having more and more inventions. Now here I am talking about various intellectual property rights. So we have seen IPR, in the IPR we've seen patent, trademarks, industrial design. So largest number of IPR files are in the trademark, that is 1,72 lakhs, whereas patents are 33 lakhs patents have been filed in the year 2019 to 2020. So the largest number of IPR filed are for trademarks. Thereafter there is a patent, then utility model, it is also almost like a patent, and third one is industrial design. So with this statistic, I hope I able to put in front of you what is the scenario in the world, how the people which are filing more patent, how they are earning more money, and same can be happen with individual also. This was the scenario, this was the picture based on country to country case, whereas the same can be applicable to you people also. Now, if I file IPR, this IPR yields the following advantages to startups. This is the individual benefit now. So if you have IPR, it can be sold or licensed for creating revenue. So even though you are not able to start your own industry, you are not able to start or launch your product in the market, you can transfer that technology by selling it, or you can license that technology to some another industry and you can earn some revenue from that. It offers distinctive product services to your customers. So if you have already existing company and if you are offering new or distinctive product, then it's a new material to your customer and your customers can attach to you for long period. Become an essential part of your marketing or branding. If you say this is the article made by me, and the another company, they can say we have made this article and we have filed the patent. We have IPR, intellectual property right of this. So automatically impression of that brand will be better compared to when you are without the IPR, and people will purchase easily. This can be used as an asset, as a security against the loans. So you can have mortgaging system with the help of IPR, or even when you have valuation of your company, like your tangible assets, IPR is also considered as an asset for valuation of your company. So if you have more and more number of IPR, your company will be with better valuation. So that is also quite possible with the help of IPR. So these are the importances or advantages of IPR for you people. Now, legal management and protection of intellectual property. It protects against any sort of infringement by others. Infringement means suppose somebody copies that product without your prior permission, you can have infringement suit against that person. You can claim that this is the product made by us. We are patent holder and this person is or that entity is using that illegally. So that is quite possible. And because of this system, people will not dare to copy your product easily. This gives ability to defend in the court to claim your sole right. This legally stops others to use your product, make your product, sell your product or import your product without your prior permission. It can also happen that you say use, make and sale, but you are importing it from other country. That is quite possible because this is the territorial right. Other countries can manufacture that product which is patented in India or some other country and where it is not patented. This is the chance to earn royalties by licensing to make money by selling or transferring the technology. One can use trademark for strategic alliances. This is also quite possible with the help of IPR or trademark. I will come with one story to you. Ex-cook head gets 8 years in trade secret case. So this is the case you can find. This is the story of 23rd May 2007. A former Coca-Cola company executive assistant was sentenced to 8 years in prison on Wednesday for conspiring to steal trade secrets from the beverage giant and trying to sell them to rival PepsiCo for as much as $1.5 million. So the formula of Coca-Cola that is not patented because patent is only for 20 years. Whereas if you go for trade secrets, that is secret as long as you are keeping it as a secret. The Coca-Cola employee got that formulation and he wanted to sell it to the Pepsi company, but Pepsi knew that this is a trade secret, and if we are buying that trade secret, we are equally punishable, and therefore instead of buying that, they informed to the Coca-Cola that you are one of the employee has approached to us and he want to sell your trade secret to us. You take the proper action against that, and that's why this happened here. This is because the formula was considered as a trade secret. Imagine it was not considered as a trade secret, it was not considered as a patent. So the company which Coca-Cola filed the case, they would not have able to file the case, and that would have been multiplied number of times, and your Coca-Cola recipe would have been available to local manufacturer. So that may be a big loss for Coca-Cola company, but they knew it, and that's why they considered it as a trade secret, as a intellectual property right. So this is one important benefit example in front of you people. Now we are coming to the patents. Patent come to play when you are looking to protect an invention that is original and can be used to simplify the lives of the people. So you want to make some article which is better in performance than previous one, that has something new, so that can be patented, and you can acquire patent rights for that invention. So this patent rights gives an exclusive authority to inventor or the patented invention. The right to exclude others means it's actually negative right and exploit the patent and earn from it. This is the right to exclude others. This is right to exclude others from making, using, offering for sale, or selling, or importing the invention in your country. So it is actually negative right. Since you may use it or may not use it, but you can restrict the use of that on the other people. So that is quite possible. It is not the right to make, use, offer for sale or import, but the right to exclude others. So it's a negative right. So you can protect others, and whether to make, use, offer for sale or import, it's your own decision because you are inventor and the right is to you people. The validity of patent, there are two kinds of validity. One is the time validity. One is the time validity. You have, once you file the patent, you have 20 years after that, and within the 20 years, you have to utilize your invention. Otherwise, after 20 years, it will be open to all. People can use without your prior permission. Second validity is about the territory, region. So if you file patent in India, that means, just a minute. Validity of patent is 20 years as far as time is concerned, and as far as territory or region is concerned, it's country where you have filed the patent, and as such there is no word patent. So that you have filed the word patent and you have protection in all over the world country, it is not going to happen. You have to file patent each and every country if you want to protect your invention in that particular country. And it's not easy to maintain or to support financially for this filing, and that's why normally people are filing in the countries like India, where they have lot of purchasing system and they can sell their product without copying it in the India. And the authority to issue, we have seen registrar in the case Tahsil place or in district places, they are issuing authority for your tangible property. Similarly here, patent and trademark offices are present. In India, we have patent and trademark offices where you can apply and you can have rights from them for your invention. So you can process patent, you can requires an idea to be novel and unique, and this patent can be obtained from process, that is process, act or method, and primarily includes industrial or technical processes for manufacturing of some material. Material may not be new, but process is new. By this process, you may be reducing the cost incurred for the process, so that process can be patented. Similarly, articles can be patented. These articles are new, maybe better compared to earlier, so this article can be protected. Composition of matter, so chemical composition, these chemical compositions, if they are giving some special properties, that can be patented here. So as per Indian patent, we can patent process, articles, and composition. And there are conditions, for 3 conditions for patenting any invention, and these 3 conditions are that it should be non-obvious. That is, industrial procedures can be patented especially if a non-obvious step is introduced into it. That means it should not like that if I hold some pebbles or stone and if I throw it will fall down. So this is the obvious process. The process should not be obvious, it should be non-obvious. Then can it be patented. Utility, it should have some utility, that means industrial application. And unless and until it is not having utility, it cannot be patented. That means it's just idea, yes, I can go to some another part easily with this and this technology. No, it's a fictitious thing that cannot be patented because it is not in the reality. So it should be reality, it should be applicable, and that can be patented. And third condition is the most important condition is it should have some inventive step over your earlier invention. The example what we have seen, comparison of old and new laptop. So that is a novelty. The old laptop don't have foldable system. That only one thing is sufficient to get the patent. That is sufficient. Other additional features, you can have more and more number of patents for the same article, same laptop or same thing. But at least minimum one step should be inventive, and that should not be known or used by others in this country, or patented or described in a printed publication in this or foreign country. Or even if it is published prior to your filing the patent, it's not possible for you to go for patent. So if you have an idea in your mind, my suggestion is don't go for exhibition. Normally what we are doing, if idea comes in our mind, we are going for some science exhibition and we are showing that yes, we can make this article like this and this is the hypothesis behind that. You are losing your idea because once it is in the public domain, it's a public property and you cannot go for patent. So my suggestion will be, if you have an idea which can be converted into reality, don't go for exhibition, instead go for filing patent. Even not only filing patent is sufficient, but filing patent properly is also important. And for that, I have taken example. Left hand side, you have Charles Goodyear, and right hand side, you have Alfred Nobel. We all know about Alfred Nobel. Few people may be familiar with Charles Goodyear. Charles Goodyear is the person who invented vulcanization of rubber, which is very nice invention, because those days we were not having polymer. We were having natural polymers, but these natural polymers were not elastic, or that time natural rubber was obtained which was elastic but meltable, and therefore that used to stick. So he developed vulcanization process. There is a long story how he developed. We are not going to listen that story, but the point is it was a very important invention. And Alfred Nobel, almost in the contemporary years, he developed some material that is a dynamite, which is used as an explosive material, which is almost equivalent invention. But he continued to patent it, and he filed around 355 patents in his life related to dynamite and other technologies. Whereas Charles Goodyear stopped after having one patent, and because of this, he has not earned the money what he should have, whereas Alfred Nobel earned a lot of money. So this indicates that don't stop if you have a single patent on your technology or invention. Go on patenting the technologies nearby to your invention, so that protection or fencing will be more and more stronger. Now we are coming to the second protection or intellectual property right, and that is copyright protection. It is normally for books, lectures, dramatic, musical works, cinematography, drawings, paintings, architecture, sculpture, photography, illustration, math, plans, and sketches. And this right provides you to distribute copies or this of the work to the public by sale or other transfer of ownership, or by rental, lease, or lending, and to perform the work publicly in person or through an audio transmission, so that you can earn money directly or indirectly. And validity is very important. For that validity, I have taken one example. Almost everybody know about this late Lata Mangeshkar. We know recently she died, but she has lot of songs to her credit, through which she was earning royalty. And this royalty is because this is a musical work, and this musical work was giving her royalty. The validity of this royalty is lifetime of the author or lifetime of the singer, and even till the 60 years after his or her death. So she will be able to continue this after 16 years, 60 years from this year. That is quite possible. Now we are coming to the next intellectual property right, that is a trademark. If you look at, there are number of trademarks given here. And you can find once we go for this or this sign, we can immediately came to know, yes, this is a good material or have a very nice, it's a nice brand. So just name is sufficient to you people. Because it's a goodwill of that company. And instead of keeping entire name of company, they are keeping this logo on that product, and that product attracts you. That is a trademark. This act as a brand, and this distinguish your goods and services from other competitors. It creates distinct identity of your product or company to secure a brand from being counterfeited. This can be word mark, a logo mark, number of examples are given, or a slogan, or it can be a shape, unconventional marks like colors, sounds, gestures, animations, holograms, etc. This gives the exclusive right to use the mark and prevent anyone from using it without your permission. So owner also enjoys the right to license, assign and sell the mark in return of some compensation. And this is for 10 years, but you can renew it after 10 years. And of course, if you launch this trademark in the market without getting its trademark rights, you can apply in latter case also, but it do not happen with your patent. Before introducing your invention into the market, you should first go for patent. But here in the trademark, you can use the trademark, but you cannot prevent others from using the same trademark unless you have its registration. That's the issue here. So when you feel now people are copying my trademark, then you can go for registration of it. And for that, you need to prove that you were using this trademark before use of that competitor. There are industrial designs also. These designs are also falling under the intellectual property rights. So other people should not copy it. So it can be feature, shape, configuration, pattern, ornament, or composition of lines or colors. And this can be fixed. So you can find many times people are going for this kind of intellectual property rights. So for single invention, you can go for industrial design, you can go for trademark, you can go for patents also. Now here we are coming to the trade secret. These are the famous trade secrets, that is formula of Coca-Cola. We know this already story we have gone through. Second is KFC chicken recipe, the Big Mac special sauce. So these are the famous trade secrets, and these trade secrets are normally taken when you want to protect your idea for long period. And here it's not only article, process, or combination or composition in the case of patent, but here it can be invention, can be data, information, any of available means of IPRs. Such information is held confidential as a trade secret. This trade secret can be an invention, idea, survey method, manufacturing process, recipe, experiment results, chemical formula, financial strategy, client database. So it can be data and information which cannot be protected by other IPR. And when you have to go for trade secret, when invention is not patentable. Suppose you have some client data. So client data cannot be protected by patent. It cannot be protected by copyright. It cannot be protected by your trademark. So that time you can protect that data by trade secret. When you want to protect your article or your invention more than 20 years, still even though it was patentable in normal course, so it can be patented, but you want to take the benefit more than 20 years, so that time you can go for trade secret. When cost of patent protection are prohibitive or expensive, you can go for trade secret. And when it is difficult to reverse engineer, means even though you launch in the market, people cannot reverse engineer, then that time that can be protected under trade secret as an intellectual property right. But there is limitation in the trade secret case. We have to guard the trade secret, and these are the ways how we can guard the trade secrets. So that can be by restricting access to secret information to the limited people only. So this information or formula should be known to the limited people only. And before having access, you sign confidentiality agreement, that is normally non-disclosure agreement. We call it as a NDA with partners and employees to whom you feel they will have access to your secret information. Use protective techniques like digital data security tools for restricting entry of other people to your restricted area. Even government or national legislations provide protection in form of injection and damages if secret information is illegally acquired or used. That was the case what we have seen in the case of Coca-Cola's recipe. That person wanted to sell to the PepsiCo, and PepsiCo knew that this acquiring this secret information is illegal, and therefore instead of getting that information, they informed to Coca-Cola company about this kind of activities, and Coca-Cola obtained some protection from the government agencies, and that happened. So these are the limitations that you have to guard your trade secret, and you need a proper system for this. So this is the organization structure of IP offices present in India. Patent offices are present in Delhi, Mumbai, Chennai, and Kolkata. So these are the 4 offices where you can file patent. Nowadays we have online filing system also. You do not need to go to these offices, but they require one digital signature. Either you have to acquire it, or you can go through your attorney, and you can give right to attorney to file your patent on behalf of you. So that time you can skip that process what you require for digital signature. Design wing is at Kolkata, so industrial designs can be filed here. Patent information services, they don't file any IPR, but this is the central office from which they are having training and some information regarding the patent. So Rajiv Gandhi National Institute of RGNIPM patent management system is available at the Nagpur, and if you want more information regarding the patent, you can find some programs over there, and you can join those programs. Even we have geographical indication registry at Chennai. I will take one example of geographical indication. This is the geographical indications means it is a special indication where you have the special kinds of material over there. We know in the Jalgaon we have brinjal or bharit, that is very famous, and Jalgaon bharit is very famous. That Jalgaon bharit is registered as a geographical indication by one of the society. The only thing is other IPRs can be filed individually. If your patent, copyright, design, trade secret, these can be filed by individual, but geographical indication cannot be filed by individual person. Instead, it has to be filed by agency or organization of manufacturer, and therefore here that buried organization, one brinjal organization is there, they filed this geographical indication, and there are number of geographical indications available in India. Even your basmati rice, Kolhapuri chappal, then Mysore sandal soap, Alfonso, that is Raigad Alfonso or Raigad Hapus. So these are coming under the geographical indication. We can register trademark to Delhi, Mumbai, Ahmedabad, Chennai, and Kolkata offices. So these are the various offices where you can file your IPR at particular office which you are going to apply. And this is the process for patent. So if you have an idea, you got it, some result, and you feel that this is very new idea and it should be protected. So you can immediately start the process to file the patent. And you know, you don't have substantial results in your hand. You want to do some more experiment, but prima facie, your first or second, third experiment shown you that your results will be better, and that time you can go for filing a patent. That time this patent is called as provisional patent or provisional specification. Once you file provisional specification, within the 12 months of that, you have to go for complete specification. The benefit of this is your date of protection starts from filing of your patent. Filing of your patent. And if you wait for complete specification and meanwhile somebody stolen your idea or file your idea as his patent, then you cannot claim. Therefore, you have to immediately approach to patent office and go file provisional specification. So you get 12 months to go for complete specification. Here you have to give your complete specification. After giving complete specification, it goes for publication. So it takes 18 months from here to here. So after 18 months, it is open to public. It is published in patent office journals so that people can see it, and if they have any objection, they can raise some objection. And immediate after that, examination process starts. So patent office examines it, whether it's really new, whatever you have told, is it correct or not? And based on that examination, they are preparing first examination report, that is FER, and within a year, you have to respond this first examination report if your patent is not granted. They may say that whatever you have, this all claims are not correct. So whatever claims are not correct, what is your regarding that? What is your opinion? You have to give as a first examination response to this. And based on that, there will be official decision taken by patent officers that whether this will be accepted or rejected. And acceptance and rejection will be done here. If it is rejected, your patent is denied. Whereas if it is accepted, your patent is granted. And this response can be 2 times or can be in the physical also. Initially, it will be on paper. So you do not need to go for patent office when you are going for APR response. Whereas if still based on your APR response, if examiner is not satisfied, he may ask you to come in physical, or if somebody has taken some objection, he will call both of you, and based on that, your rejection and acceptance will be done. So if you have acceptance, your patent will be granted. Even though it is rejected, you have this span of 2 to 3 years in your hand to protect your invention from others. So many people, what they are doing, even though they are not going for commercialization, but they go for filing the patent. So filing patent is very important, and acceptance is a later step. So management of IPR to protect invention of startups. Here you can find protection from copying. If you file the patent, people will not copy it. And being a startup, you don't have physical infrastructure to immediately launch your product in large quantity in the market. And that benefit can be taken by some other organization which are competent to copy it immediately and put it into the market compared to you people, and therefore you will have business loss over there. So you go for protection of filing patent. Other IPR literature study you are doing, or you are while writing your patent or drafting your patent, you are coming to know about other IPR literature study. So that is also improving the quality of your product. High valuation of technology transfer. If you want to transfer the technology, one is without patent and one is with patent. So that time, the people whosoever want to take your technology, they will consider high valuation of your technology. Increased trust of inventors. Image of startup in society is better. Confidence of startup that yes, we have patent of this and nobody can copy it. So this confidence will be with the startup. So these are the things behind management of IPR of your invention. Especially this is very important for the startup people. Now I am coming to the almost last topic, that can we manage business without IP? So I have put here two conditions. One is total unique idea and another is your existing idea which is already running in the market. So let's see for first case, that is total unique idea. So you can, your options is yes, I can manage my business without IP. Yes, without intellectual property, you can do your business. But if you don't have filed your patent or if you don't have IPR, then it is quite possible people can copy your invention and they can launch first, second, third copy immediately, which is cheaper than you people. So you will lose your business. Though you can do business, but you will lose the business. And therefore, my opinion is option 2, don't do business until you have IPR of your invention. Second is, it's not a new idea, it's an existing idea. So can I use earlier patents without infringement? Yes, I can use earlier patents without infringement. In last case, we have seen the literature we are reading when you are going for filing the patent. So that literature reading is giving you something new, which is not with you people. And that patent, which is earlier, can be utilized without infringement when the patent's validity is expired. Normally, we have seen it lapse after 20 years. But sometimes within this 20 years, you have to pay some fees to government organization. If that patent applicant failed to pay the fees to the government, that time it can be expired earlier than 20 years. So that is one possibility. Second is, after 20 years, automatically the right is lapsed. When patent is not filed in your country, suppose they file it in China, US or some other country, you can use it in your country. Get license of the existing patent. This is also possible for existing ideas. Suppose its validity is still present. It has not lapsed because of 20 years not completed and patent is filed in your country. So you can go for license. You can ask to that industry, as you give us technology, I will pay this and this as a royalty. So this is quite possible for you people to use others' IPR with consent or without consent also. So these are the possibilities. How can you do business without IP? Now the last topic is for the startups. It's not easy to go for IP or some technical and business mentoring, access to state-of-the-art lab facilities, workplace, connect in the market, IP or legal testing support, and IP and legal connect. So it's not easy for individual, and therefore you can attach to any incubation center. I appeal to you people. We have KBC NMU Center for Innovation in Incubation and Linkages, that is KCIIL, which is an independent incubation center of KBC NM University, Jalgaon. And you are fortunate enough that we have extended the last date for the submission of application from 15 February to the 2nd March of 2022. So you can apply, you can come in the this batch for availing incubation facilities. Details are available on website also. You can go to kbcnmu.ac.in or you can search for KCIIL Jalgaon. You can find details also. So with this, I thanks to you all people for patient listening this presentation. Thank you, sir.
Dear participants, if you have any questions or doubts related to intellectual property right, so you can ask Dr. Gite sir now. The session is open for discussion. Sir, you talked about intellectual property right also in your session. So what happens is that like there are some best-selling writers like Chetan Bhagat, and obviously they are the original writers, so they own the copyright of their books. But it is generally seen that when we go to the local states, so the pirated copies of the books are sold there, and some people earn money illegally. So I mean, what can be done in order to avoid this illegal activity, sir?
Yes, sir, it's a very nice question. Actually, government organization is just providing the right. It's you that you have to protect your rights. Okay, unless and until you are bringing this in the notice to the government that this person is copying my copyright written articles without consent, government will not do anything. So this is our duty to file the infringement suit against this kind of activities.
Our duty means the author's duty. Is that what you want to say, sir?
Pardon, sir?
Our duty means like means the
Our duty means
the person
applicant's
who owns
duty.
the
It's applicant's duty.
okay.
If you file the patent, government will not monitor that patent is filed by this XYZ person and the same invention is utilized by other people. Government is not going to monitor.
Okay.
It has to be monitored by applicant. If I have filed the patent for this invention, is this invention utilized by other people without my consent? That is our duty, applicant's duty. And if it is the case, we can file patent, infringement suit against that company. There is well-known infringement suit with Apple. We know Apple is a very high brand mobile phone company, and it was considered that some Samsung copied some of its feature and launched in the market. So it was proven, and that there was a settlement, and this settlement standard at around 7,000 crore rupees. Samsung paid 7,000 crore rupees to Apple against the infringement suit. So, but Apple has to identify whether Samsung is copying something or not. It's not government organized. So Chetan Bhagat or the owner of that copyright, that publisher, should identify who is copying that without their consent, and they should stop that.
Okay.
So legal action is possible there.
Okay. Yes, if other participants want to ask questions related to intellectual property right or patents or uh, trademarks, so yes, the session is already open for discussion.
Sir, my question is, in the market we find similar products, just like Dr. Aquaguard is there. So similar product like Aquafresh, Aquago, such kind of products are found. So can we call it as an infringement of the product?
So, Dr. Gite sir, are you getting voice?
Yes, sir. Now I'm in. There was a disconnection at my side. Damale sir, please, what you was asking?
Sir, my question is that we find the similar products once the product is invented and is launched in the market. The similar products are copied and they are sold in the market. Just like Dr. Aquaguard is there. So we find a similar product like Aquafresh, Dr. Aquago, like that. Just a Bisleri was the first product which came into the market. Then we found Kinley and other similar products are there. So can we call it as an infringement of the trademark or copyright or whatever it is?
Yes, sir. It's a very nice question. Actually, it's not infringement because everybody is having new technology. And when you go for patent filing, you have 10 claims possible. So in the claims, what you mentioned, that is very important. What are you claiming for? And normally it happens, you may lose something in the claim, and the benefit of that can be taken by some another industry. And that happens normally when any company is launching any product which is totally new in the market. But immediate after that, people are doing R&D over there, and they are trying to find out the voids of free spaces where they can enter with the similar kind of product in the market, maybe having some another patent. And therefore, it is necessary to file continuous patent on the same invention. And for that, I shown example of Goodyear and Alfred Nobel. Alfred Nobel was the person who continually filed patent over the dynamite kind of material. Otherwise, you would have lost the market what you are talking about. So Kinley and Tinsley are not having same bottle, they are having different kind of bottle. They may be having different kind of water quality. So they are getting different patents over there. Okay, sir?
Yes, sir. Thank you. Thank you.
Thank you very much, sir. Any participants, any other questions? Hello, sir.
Yes, please.
Sir, last question was there from my side. Sir, am I audible?
Yeah, you are audible, sir.
Yes, sir. Sir, as the manufacturing companies are there, which keep on inventing the new models, so can it help to save some taxes, or it is just for being in the market with the new secrets?
Yeah, that is totally different question. It's not related actually to IPR, but instead of saving the taxes, they are launching new model. And people, many times it is, you can find in the market that people want something new than older one. So that time they can catch this kind of customers with new material, as well as when you are inventing something, you may get some new features to your product. So that will be added advantage to those company. I don't know about the taxes and other, but I don't think any taxes exemption is with the new invention to those people.
Hello, sir.
Yes, sir, please.
Sir, I want to know how to patent, means in which category the poetry and shairi will come for registration of
That falls in the copyright category, sir.
copyright. Okay. So, means where we need to register it.
You have to register copyright. Even you have not registered, you can, it will be with you, but you cannot deny copying of others in that case. You need a copyright for that.
So, how to apply for that copyright particularly?
Yeah, normally, sir, this is the case that it's like an attorney. If you have any case in the court of law, and it's right of us individually to fight against that, but normally nobody is going with that. Everyone goes with attorney.
No, I want to apply for copyright for my particular
Yes, sir,
poem.
yes, sir. I got your question. I got your question.
Yes.
But if you go individually in the court of law, the other party is have some attorney.
Okay.
So that time you will lose your case. Same thing happen in this case also. Normally we have to go approach to the attorney if you don't know. So through the attorney you can apply it. So your all aspects will be covered in that case.
Okay.
So patent attorneys are there. They may be specialized in the copyright and something like, you can go with that. Normally publishers are going for that.
Okay, sir.
Okay, sir.
Thank you.
Well, if the still some questions you can ask Gite sir.
Yes, sir. From my side, it is over, sir.
Okay, sir. Well, it's time to propose vote of thanks. So I would love to express my deepest gratitude to Dr. Gite sir for conducting this extremely informative and detailed session on intellectual property right and all the important things which are related to that. Sir, I really hope that this session will definitely help me and all the participants a lot. Once again, thank you so much, sir, for joining with us today for this session and conducting this session. Thank you so much, sir.
Thank you, sir. So may I leave the meeting, sir?
Sorry, sir?
May I leave the meeting now?
Yes, sir. Yes, sir.
Okay.
Thank you so much.
Okay, thank you, thank you.
Well, our coordinator will get back to you, sir.
Yeah, okay. Thank you.
Okay, yes, after some time. Yes, dear participants, we will take a short break and we'll meet at 4. We'll meet at 4 after 15 minutes. Thank you.